Let's take a look at the issues around enforcing labor agreements. Rather than require lawsuits every time an employee's rights have been violated, labor agreements usually provide grievance procedures ending in arbitration if necessary. Employees who believe that their contractual rights have been violated can file grievances, or unions will do so on their behalf. The grievances will be considered by successively higher levels of management and union personnel. The representative role of the union must be respected in the contract administration process just as during negotiations. Although individual employees can choose to file and pursue their own grievances, unions must be notified and given opportunity to have representatives present at any meetings about grievances. Most importantly, individual employees and employers cannot agree to resolve grievances in ways that would alter or conflict or contrast the labor agreement itself. The availability of a grievance procedure also means that employees cannot take contract enforcement into their own hands, such as by refusing to follow orders that they believe are contrary to the labor agreement. Instead, they're required to follow the orders and file a grievance. If a grievance is upheld, the employee will receive a remedy for the violation. Grievances that cannot be resolved by conferences between representatives of labor and management are sometimes submitted to arbitration. Ultimately, the union decides whether to take a case to arbitration. In grievance arbitration, the arbitrator decides disputes regarding the interpretation and enforcement of an existing labor agreement. The courts have made it clear that arbitration is the preferred means of resolving disputes about rights under labor agreements and that arbitrators' decisions are generally final. Arbitrators have a great deal of leeway in interpreting labor agreements, but their decisions still must be grounded in or draw their essence from the language of those agreements. Labor agreements between unions and employees are more than words written on paper. Grievance procedures and arbitration are critical in defining the rights of the parties under the labor agreement. Employers should handle grievances and arbitration cases very carefully, including gathering the facts and carefully considering which cases should be settled or allowed to go to arbitration. The labor agreement sometimes extends to ongoing practices of the party, even when these are not explicitly or not at all mentioned in the labor agreement. A change in circumstances, like the installation of new equipment, or in contract language, is likely to invalidate a prior practice. Past practice cannot be cited to create rights that conflict with the clear and unambiguous contract language, but it can be important in supplementing labor agreements when they're silent or unclear on a given matter. After all, it's reasonable to assume that the issue presented in a grievance has been dealt with before, and the manner in which it was handled conveys important information about how the parties understand the agreement. In light of the importance of past practice in arbitration, unionized employers should not establish informal practices of conferring benefits or privileges not specified in the labor agreement unless they are willing to sustain these practices. Both employers and unions have a responsibility to ensure that it's being enforced in a manner consistent with the understandings at the time the agreement was reached.